Hi guys, welcome back to my channel. I'm Raji, and today's topic is justice and election integrity. In your court of public opinion, you decide. I'll bring you the facts, I'll bring you the law, and you decide. I believe the American people are very smart, educated, and filled with a lot of common sense. So my case is about a lot of common sense, a lot of things that are legally very clear, and things that cannot be changed by any judgment. So let me go back a little bit, okay, so that you understand. Election laws, election codes are designed by legislature in the best interest of the public, so that one side or the other, when they get into power, they're not able to manipulate or maneuver through those laws. Okay, so if party A is in power, they should not be able to squeeze and change the laws to their advantage to put the party B down, or in that case, party B, when they get into power, they're not able to squeeze the law to their advantage. So this is how the legislature intends to make those laws. And even when these matters go to court, the judges do not have any authority to put words to change the meaning or to be able to change the foundation of the election code, because the courts are constituted by authority and they cannot go beyond that authority, because if they do that, their judgments become void. Okay, after having said that, I'd like to come and get into a little deeper on this. As we all know, we have entered into a very, very advanced stage of the midterm elections. It's a very hot topic, hot season for elections. A lot of arguments going on from both sides of the aisle as to what has not been achieved and what has been achieved. But I will come down to something that we have all got a common ground on, whether it's the Republicans, whether it's the independents, or whether it is the Democrats. I believe those in the helm of affairs, the party that is in power has more responsibility to make sure that the election codes, the election process, and the methodology of election process is very, very clear and transparent, not giving any room for any doubts, or for that matter, any arguments after the elections to contest the election results. I'd like to go back to the fundamentals of my case here today that I present to you, my dear fellow Americans, for your court of public opinion. Okay, so in the last election, I ran from District 30, which is District 32 right now, and I'm very popular in the district. You know, from the fast food restaurants to malls to 7-Elevens to liquor stores to the people on. Everybody knows me. I'm well known in the district, very well known. Even when I'm driving by, I get honks and waves and all that. I'm very popular in the district for the last so many years. Okay, so I'll just come down to the point. Instead of explaining all the good things that I've done in the district, I'll just come down to the matter in question right now. So the matter is that I ran for elections as a congressional candidate, and we were planning celebrations because we had excellent feedback from exit polls. And at the night of the election, the results were totally upside down. So I was taken aback. I made some questions, and I was told by the innocent people working at the registrar office, they gave off the truth. They said that I asked, when did you start counting the ballots? And they said they started counting the ballots 20 days before the election, or, many days before the election or so. So I was taken aback because I know that there is an election code, a code on the foundation of which our elections rest, because we are the role models of democracy. Okay, we want to make sure whoever wins properly and respectfully. So I was taken aback. I asked questions from the higher ups, and then I was getting different answers. In fact, I was told that yes, we did start scanning the ballots. We did not count the ballots. So I had to go to court and get the operating manuals of the machine that are counting. These are Smartmatic VSAP machines that were bought at a very high expense, over $350 million or so. So these machines were used for scanning. They said we did not count the ballots before 10 or 20 days before the election, but we did scan them. But my question in that regard was, do the machines count as soon as the ballots are scanned or not? And I was told a lie. I was told that these machines do not count, and this was a blatant lie that was thrown at me over and over again till I went into court. Even in the court, I was given under oath these misrepresentations that these machines scan and do not count. They are not two-in-one machine. They just scan. They do not count. And they're just scanners. But when I was able to research through the thousands of pages of document that I had to research through, I got the operation manual in which it states very clearly, there's a diagram that very clearly explains that as soon as the ballot is scanned, no matter how many days before the election, it counts. It decodes the ballot is immediately decoded, and it's counted. And who's got the count machine in their hand? The registrar, Dean Logan, has the fullest authority and control of that machine. So it's in the hands of one party, one person. And God forbid you are not in the good books, or you're not the candidate that is chosen as a favorite, you're doomed. So basically, they started counting the ballots days before the election. Now there's an election code, okay? Election code, that's the religious line there. It says, under no circumstances. And the name of the election code is election code 15101B. Okay, I'm talking to everybody here. Okay, I'm not specifically talking to my Democrat friends or my Republican friends. I'm talking to all Americans to educate you on the subject. You guys must know. You must know what the law is. And the law is that you may start processing the ballots 10 days before the election. Processing meaning a lot of ballots that come in, the envelope get torn down or something, you take them out and prepare them for machine read, meaning machine read could be scanning, but you can prepare them for machine read, but not for counting. If the machine is doing scanning and counting, illegal right away. You can prepare them for machine read. And when does the scanning should start? Now this is the controlling part of the law. It says, but under no circumstances may a vote count be accessed or released before 8 p.m. on the day of the election. I say again, but under no circumstances may a vote count be accessed or released until 8 p.m. on the day of the election. Now, where is any confusion in this? Where is the confusion? Is there confusion in the language? The language was perfectly implanted, perfectly composed by the legislature. The intent was to remove confusion that nobody will count the ballots before 8 p.m. on the day of the election. Why? Because if they count the ballots 8 p.m. on the day of the election, there's no room for any malconduct. There's no room for any cheating. There's no room for any favoritism. Okay? This is why the legislature intended Election Code 15101B the way it is written. It is well written. And if any court of law tries to change the wording of this election code, or for that matter, any statute, then that judgment is void. And there are a bunch of case laws on that. So I went to the court. I spoke to the judge. The case was stretched. I said, I filed a writ. I want an answer quickly. I was in the primary election. I wanted to get my name on the November election, and the respondents stretched and delayed. So I had filed the case under two grounds. One, 16100A, that there is malconduct, and 1600G, that the summation of vote count has been, impacted. So basically, there is an error in the summation of vote count. And the reason there is a summation error, because there is malconduct. So if I prove malconduct, I automatically prove 16100G. That means there's the error in the summation of vote count. Okay? So I had a very strong case. I proposed and presented a very clear case that Election Code 15101B has been violated. And violation of Election Code 15101B renders malconduct. malconduct by Registrar Dean Logan, by the county, whether the Secretary of State, who's the chairman of the Election Commission, the registrar, and the Board of Supervisors. So I filed my case and took these people to court. And their answers and replies were completely baseless. They started to say ultimately that they're allowed to count ballots before the election. For that matter, they can start scanning ballots. You can start scanning ballots if they are not doing the count. Down the line, first they said these are not 2-in-1 machines. Can you believe this, guys? You tell me. One guy says, these are not 2-in-1 machines, okay? Right in the beginning of the case. And this is in writing. These are not 2-in-1 machines. And then later on, when I bring in evidence, oh yes, actually they do scan, but they're in two parts. There's a hardware and there's a software, and the hardware does the scanning and the software does the counting, but they are all together. So it's called VSAP altogether. It's called the Smartmatic machine. It scans and instantly counts. So when were you lying? Were you lying in the beginning or were you lying at the end? And I presented this matter to the judge. I said, Your Honor, these people have lied, made blatant misrepresentations. But my plea remained unheard. It was heard, but there was no reflection of any responses from there. And to come down, to narrow the subject down, is the fact that ultimately the ruling that was brought down. Just before that, I want to add one more point, okay? So I did prove the fact that malconduct is there. I established that with clear and convincing evidence that the law has been violated, okay? I was asking throughout my court case, please give me inspection, because I also wanted to narrow down to how many votes they took out of, that were given to me, and what was the summation error? How much? What did they do with all this vote that they took out of me? Or how did they distribute? Or what was the summation error? They did not allow that. I kept asking. First they said that, the machines are, have been disassembled, they have been moved. There's so many excuses. And as soon as the machines got back for the November elections, I said, okay, now the machines are back in order. Let me have the inspection. Now you're late. So I filed the request with the court in ex parte, and I said, Your Honor, I've been asking for inspection throughout. And one more thing happened in that due course was that I was given a protective order. I said, Your Honor, these machines should not be touched till I've given an inspection. So I was given a protective order, and soon after that, the county respondent filed to they filed to oppose my inspection of the machines, and they said that the protective order be removed. Now, they asked that the protective order against me be issued to the county. I'm not, I don't remember exact specifics on that. Excuse me, but in order for a protective order, let me be clear. I'm just trying to go with my memory. I'm sorry. I was given a stay order. I requested a stay order that the machines not be moved. Judge gave a stay order that everything should stay the way it is, the machines, till the final decision of the court. The respondents filed for the protective order that I should not be allowed to inspect the machines. Now, the requirement for the protective order is there's got to be an email exchange where they have to inform me that we are filing a protective order, and under these grounds or whatnot. They did not send me an email. What they were communicating with me was about my inspection, and then they filed a protective order, and I told the judge, I said, Your Honor, in order for you to grant them a protective order, there has to be an email communication under the law where they have to inform me they are filing a protective order, and I should be able to answer it accordingly. They did not send any email, so this is defective. But that was set aside. So my grounds were not given any weight. And coming down to the gist of it, I'm just coming down to what the judgment was. And the judgment finally was given that the law, my grounds that under no circumstances may a vote count be accessed or released before 8 p.m. on the day of the election. That was completely, overruled, and the judge made her own judgment by changing the election code 15101B, by putting her own adds and her own meaning to it, and saying that for all future election, I'm going to make this ruling that this section of law, election code 101B, does not apply to computers. Oh my God! If that is the case, anybody who hacks into somebody's computer will use this ruling and say, it wasn't me. It doesn't apply. The computer did it. I didn't do it. And I said, excuse me, who was using the computer? The registrar's office and the registrar at the helm of affairs were in control of the machine. They were scanning. They were using their hand to scan the computer. The computer didn't wake up one day and start scanning by itself. But what can you do? The great thing about our justice system is there is an appeal process. So right at the end of the ruling, I told the judge at that point, Your Honor, I will be filing an appeal to this case. I did not wait. I did not give it an afterthought. I told the judge right there on the face of the judge during the hearing that, Your Honor, I will be filing an appeal. And I did. Because if I don't file that appeal, if I don't fight it, we're all doomed, because that law is going to completely mess up our democracy. Not only California, all the other states are going to use the same law. So whoever is in power and wants to, wants to twist the law in their side, they're going to do it. And it happens. It happened. Here, what we are being told is we are supposed to just trust the registrar. We trust to, whoever the government is, we are just supposed to trust them. If we have to trust them, then why there be so many laws? Why there be so many penalties in case of election fraud or malconduct? Because the thing happened. There's a lot at stake, and people who are holding on to their position don't want to go. They don't want a fair, equal opportunity for anyone. So my rights were totally discriminated. I went in, stepped in, and felt the prejudice right from day one. Right, the attitude, the way I was being talked to by the judge, by the court, by the staff of the court, the way I was pushed back. I wouldn't get any calls back. I would call the court, ask for dates. Nobody would respond. And I knew that I was up against the wall. But you know what? I fought it. And I fought it single-handedly. I did not have any attorney standing for me in the court. I was standing myself. I was doing my own research, nights and days. No congressional candidate, nobody has done this in the court, because I believe it's my right, my duty to fight in the court. And that's where I stand, my fellow American. I want you to know where I'm coming from. I fought it on my own. So I went to the Court of Appeal and I filed my appeal under the questions of law and de novo review. Now, let me tell you what this is. There are other grounds that they can use, abuse of discretion or such as, but I went under the questions of law because there was a huge misinterpretation of law. There's a huge, dismantling of the election code and being reframed in order to support somebody's judgment. Wow. No. The great thing in our justice system is, this is why I want you to have hope in the justice system, my fellow Americans. This is why we have a great justice system. You can go and file an appeal. Yes, it's exhausting. Yes, it is. Yes, it's exhausting. I'm exhausted, but I'm at it, and I'm going to fight all the way to U.S. Supreme Court if I have to. So I filed my case, my appeal against the void judgment of the trial court. Why is it void? Because any judgment that I'm going to read it from here. The words of the statutes, if the words of the statutes are clear, the court should not add to or alter them to accomplish a purpose that does not appear to be on the face of the statute or form of its legislative intent. So I'm just reading the gist of it. It's People versus Knowles. But in my case, Raji Rav versus Secretary of State. Raji Rav versus Secretary of State, California, the election integrity matter. Judge in this case changed the election code, added words to it, made it void. So anywhere, any judgment where the trial court goes and twists the judgment and changes it and says now for the future references, this is what it's going to mean, that means that judgment is void. So I went and filed my case in the appeal under the questions of law and the de novo review. De novo review. Questions of law, de novo review. I'm trying to put that in your mind. Questions of law and de novo review. What is de novo review? De novo review is where the appeal court will look at the entire case, not just pick and choose where the respondents try to shift and drive the case to. The entire case, because the respondents, county respondents, they have attorneys. They're good in, that's their job. They're good at shifting issues, turning around, reframe the matter, readjust it from its original prima facie case. And that's what I've been fighting throughout. I'm not only facing legal thing, I'm looking at all the trickery that's going around to bring things back to their clear perspective. My fellow Americans, I'm not an attorney. Okay? But I've done my research and I'm inspired by Abraham Lincoln. He read a lot of books and studied law, and then he became a lawyer and, icon, historic icon. And we have many great people like that. And I'm trying to leave a legacy behind, just as much as I'm putting my word into this. So, although there's so many issues facing us, as we are moving towards advancement, but all our advancement, all the promises that any congressional candidate, Senate candidate, any of our politicians make is on the basis of their election. And if we are choosing one person and there is fundamental flaw in the system that's picking at another, we will never be able to get our voice across. Never. And I'm fighting for that, so that when you go and stand in line, my dear friends, my dear fellow Americans, I love you so much. You guys are going to start getting your vote by mail. You're going to fill them up. Some of you who don't have time will have to go. Many of you love to stand in line and cast your vote because you want to feel the power of your vote. You stand in line and cast your vote. But what good is it that after you do all that and you trust the system and there's another undercurrent in the background after you have, placed your vote in the envelope, after you place your ballot selection in the envelope, and after it is scanned and there is violation of law and those ballots are in unclean hands. We don't want that. We don't want your ballot. I don't want your ballot to fall into unclean hands. I want your ballot to be counted as fair. We are talking about our Constitution, which gives us the right to free and fair election. Free election? Okay, let me come down to this point. If you are a candidate and you want to make a little write-up in that booklet about election candidate, it's thousands of dollars just to put 10 lines. Thousands of dollars. It's not a free election anymore. Thousands of dollars just to put a few lines about yourself so the people can read it. Okay, this is the official election book that is printed by the county, California election. I cannot believe it. Thousands of dollars to educate the people about who you are, what your grounds are, and so they should be able to see, okay, the difference between candidates. Here's this guy who's been fighting for our rights for years. Here's this guy who's transparent. We know him. We see him by face. Here's a guy, a face that we can trust. Here's the guy who's been working with homeless people. He's been fighting for affordable housing. Here's a guy who's trying to build bridges between the law enforcement and the community. Here's a guy who's been mentoring students. I'm all about my district. Everybody knows me here. And I had a big responsibility. And the fundamental requirement and the platform about democracy is the election, isn't it? Isn't it all about election finally? Aren't we in that season, the hot topic election? And we take it for granted that everything is set. It should be. It should be clear and transparent. It should be free and fair. So it's not free right now because candidates have to spend a lot of money to pay the county or the state of California to put 10 lines about them. Every candidate should get a free one page to write about themselves. Why not? So it's not fair. It's not free. Coming down to fair, there's malconduct. Election codes are being violated, and then the court system, the trial court, goes on. And it looked like, to me, it was like I'm not only fighting the respondents, I was up against the trial court in trying to explain the simplicity of the matter. It was just in plain sight that election court says under no circumstances, guys, you tell me, what part of this line you don't get? Under no circumstances may a vote count be accessed or released before 8 p.m. Under no circumstances may a vote count be accessed or released before 8 p.m. on the day of the election. What part? It's clear. Do not count the ballot before 8 p.m. election night. It's clear. What part is confusing is when the registrar office and the county response say, oh, we scanned the ballot. These machines just scan the ballot. They do not count the ballot. Over and over again. These are just scanners. And then when the matter proceeded, I fought it at the end of the case before the final judgment. When the statements started coming, their own technical experts started saying, yes, when the ballot is scanned, it is counted, but we don't release the result before 8 p.m. Who cares whether you release the result or not? You already violated the law. You counted the ballots. And you expect the American people to trust you? So this is what it's come down to? The nation is divided right now on these issues, and you are saying that trust us? So I have to go, and the entire American people have to go by the trust us vibe. We have to trust them. Forget the laws. They're violating the laws, but no, just trust them. So when were they lying? When they said these machines do not scan and count? Or when they started saying, oh, they scan and count, but we don't look at we look the other way. We're not looking at the results. We don't just release the results. So we are supposed to trust them. So there's a huge, monumental violation of law, my friends. Monumental violation of law. That's why, excuse me, that is why I'm running for Congress. This is one of the reasons. Public safety, yes. Affordable housing, yes. Constitutional rights, yes. Seniors protection, yes. Prescription drugs, yes. To make them affordable, yes. Bringing jobs back to America, yes. And most fundamentally, I'm sorry, I'm injecting this issue right now, is the medication. The manufacturing of medication in America right now, it hurts me to death that our medications are being manufactured abroad. So God forbid we have an issue internationally and they block our medication. We're done. We're doomed. The reason that the prices of the drugs, prescription medication is so high is because they are being manufactured abroad. We have no control over the pricing. We should bring medication back home. We should have manufacturing here, and we should manufacture drugs here so that we can control the pricing. That's going to boost the economy, by the way. But coming back to the area of justice, election integrity, in your court of public opinion, I filed an appeal. Under the questions of law and de novo review. The reason I'm repeating it, please, allow me to repeat this, because I want you to just remember this point of my grounds of filing the appeal. Questions of law and the de novo review. De novo review meaning they're going to review everything, the entire case that I submitted in the trial court, and look at all the mistakes that happened during the course of the trial court, and that leading to the judgment. So I filed the appeal, and what I get, right down the line, just before the deadline, the respondents filed for extension. They filed for an extension. Here, I filed an appeal so that it can be urgently heard, so that we have a decision before the next election, so that they don't do it. Although I know under the law, once the appeal is admitted, the trial court judgment is already on a hold. It's already on a stay. Because my grounds is that judgment is already void, because the judge tried to change the law. Okay? Not only the interpretation of the law, the misinterpretation of the law, the ruling by the trial court changed the election code itself, and then that amounts to adding words to a statute, and it's void. So I filed that, and these guys take extension. As soon as the time for the extension is ending, Secretary of State, attorneys go and file for another extension that they're busy. Oh my God, they're busy? Really? Every attorney is busy. They take hundreds of cases. Of course they're going to be busy. Of course they're going to be always busy. They will always have something going on, but that should not be the ground to get another extension. They were according another extension. And now, election is round the corner, my friends. Round the corner. You should know this, because I'm bringing this matter to you. So when you cast your vote, you know what the hell is going on. What is not about any party matter, man. It's a totally non-partisan issue. Okay? But you have to know, because this congressional election is where you choose the right person. You choose the right person because that person is going to be available to you in times of need. So I received one of the responses to my opening brief in the appeal by the county respondents, and guess what? I filed my case under the questions of law and de novo review, and their response comes in, oh, this matter is not this matter is about abuse of discretion. Excuse me, I filed the case. I have the right to go to court with my grounds on the appeal, and I used the grounds of question of law because of the interpretation of statute there, and I requested a de novo review. I did not file my case under abuse of discretion. No, I did not. And here these guys come and say, oh, this case actually is a case of abuse of discretion. Under this abuse of discretion, Court of Appeal, even if they disagree, the trial court judgment remains valid, or something like that. Okay, I'm just explaining to you the gist of what they've said. My dear fellow Americans, we cannot allow this. We cannot allow this trickery. I'm expecting for the Secretary of State, who took another extension, second extension, and his extension is going to expire, soon. And thereafter, they have to bring in their responses. And there is no response. What response? It's such a simple matter, my dear fellow Americans. It's such a simple matter that the election code, the legislative intent is clear. You tell me, under no circumstances may a vote count be accessed or released before 8 p.m. on the day of the election. There is no room. It's very clear that don't access the ballots. Now, their ground is, the moment we start receiving the ballots, actually we're accessing the ballots. No, you're not accessing the ballots. You get the envelopes. You can open them and prepare them for machine read or machine count or whatever. You can prepare them. You cannot start counting ballots, especially when these scanners count the ballots right away. These scanners, the moment you put batches of 1,000, it does in instant lightning speed, it does the counting. So there's no ground that we're trying to save time to start scanning ballots early so that people don't have to wait. No, people can wait. People want transparency of elections. There's no rush on that, and especially when those machines are counting ballots at lightning speed. My dear fellow Americans, I reach out to you. I reach out to share with you, to educate you on this subject, to apprise you of the matter of such national significance, because if we don't control this, then we are going back to Stone Age. Because might is right. Anybody who gets in control of an election system will remain there forever. Tomorrow, party might change. Results might be something else, and whoever gets in there is going to take it to their advantage, to no end. So I'm just sharing with you, because right now this is the hot season. The vote by ballots are going to be coming in. I want your support. I want your support. I want your support in this matter. I want your vote, because I'm fighting for this cause. I'm the only candidate fighting on my own resources, alone, single-handedly in court for years. Initially, I fought it all the way to US Supreme Court earlier, when they had the punch system, where they will give you a punch position number, and then change it later. Then they changed the machines, and now they start scanning early. And the scanning is counting, which they said, we're just scanning, we're not counting. Lies upon lies upon lies upon lies. Lies upon lies upon lies by the registrar office. If you look into the Registrar Dean Logan's record, if you go online, check it, it's loaded with complaints. Loaded with complaints. Why is this guy there? Why is this gentleman there who has complaints after complaints after complaint? Because he's influential. Look up the meaning of influential, because there are certain people who are happy with his presence. The people who are happy with his presence. Who is involved in this purchase of these very, very expensive hundreds and hundreds of millions of dollars, these vote count machines that scan and count at the same time? Registrar, Board of Supervisors. When such machines are bought, they should be transparently shown to the people online every step of the way. Not like, hey, we're going to be doing this. Anybody wants to come and visit us someday? So few people will go. They'll be rushed through, and that's about it. I've gone through each step. I'm sorry to use the word, it's a shady operation. I'm so sorry. It is so vague. It is so vague. But the law is clear. The law says, under no circumstances may a vote count be accessed or released before 8 p.m. on the day of the election. That's clear. So if we want to make this case really, really short and simple, what is the law? Are we following the law? If we don't follow the law, then it's violation of the law that constitutes malconduct. Okay? So malconduct falls under 1600A, that it is established that there was malconduct. That's what my case was. I wasn't saying that, because they already took my victory away from me. I said, okay, you can take my victory. You cannot take my pride away from me. Okay? I'm going to fight for the right of the people, and I'm going to prove the fact that you cheated so you don't do that again. I have to bring that out there so that it doesn't happen again. The next election is coming, and they're ready to do the same thing again. Although the judgment of the court is void, but knowing these people, they're going to bring another bunch of attorneys. They're going to do what they want to do, and they will have people like me fight up the hill. They want to exhaust me. They want to defeat me by exhausting me, not because of fairness and equality, because of injustice that they can use at whatever tools they have in their hand. But there is justice in this country, my fellow Americans, and that's what I'm seeking. That's what I'm seeking, because I'm worried about the midterm elections, that although the judgment of the trial court is faulty, it's void, the registrar might try to start counting the ballots again 10 or 20 days before the election, and the only purpose to do that is to change the results, to manipulate the results. Why would somebody go to the extent of violating the election code? Why? Because he's so kind and energetic that he wants the results to come out quickly. No, there's no such thing. Follow the law. If you want to be kind to the people, if you want to work in public interest, you cannot take the law in your own hands. The registrar of LA County has taken the law in his own hand and supported by a board of supervisors, fully supported. Why? Why is there so much of love and support for the guy who's violating the law? Why? I leave that question to you. I leave that answer with you, because I am raising this matter in the court of public opinion. Your court, you decide. Like this channel, subscribe for it, because I'm not scared of the harm that might befall me. I'm not scared of a bullet that might come towards me. I believe in the purpose of life to bring out the facts. If there is a violation of law, I'm going to bring it out. And I've not just been saying it, because if I did not go to the court, then I would be they would say that, oh, why didn't you go to the court? If he felt so strongly about it. I went to the court and I've proven my point. I've proven the law, and I brought it to your court of public opinion. You tell me, guys. Share my video. Decide. Make this a discussion at home. Make this a discussion on the street. Make this a discussion on coffee shops. Make this a discussion of political science classes. What am I saying? It's not about me. It's about everybody. It's about our constitutional rights. It's about our values around the world. We send our delegations to check on the election transparencies all around the world, because we are the beacon of democracy. We are the light towards fairness and equality. People all over the world, when they get injustice, they come to America. I'm an immigrant myself. I've been hurt with injustices in my life, and I have come down. I will not let this happen here. I understand the plight of the people. They trust, they go, they stand in line, and next day they move on to their livelihoods. But their livelihoods will continue to struggle if the right person is not selected for the job. They voted for me, and the election system manipulates and brings out other results and say, no, trust us. But there's a violation of law. No, don't forget about that violation. That's nothing big, but trust us. But the election court said, ignore that. Ignore that. And then what? Oh, no, you don't have any evidence. Evidence? I have evidence. In open court, I raised out, a big diagram. I don't know if I have it here with me. I raised out that big diagram. By the way, my final case was on Zoom, and publicly I raised out the diagram, the evidence. I said, Your Honor, I have evidence, admissible evidence. That is not mine. It's a document from the county that I received through the court case process, through the process of the court proceedings. And I explained that this diagram clearly explains that as soon as the ballot is scanned, upon scanning, the ballot gets decoded and counted instantly. That's evidence. And they say, oh, he has no evidence. I said, Your Honor, this is the case. The election code, the statute, it's so clear. It says under no. Oh, guess what? The ruling says that under no circumstances, the words do not apply to computers. Guys, you tell me, in this world of modern computer sciences, if somebody says that the law doesn't apply, when you count, tomorrow it's going to be the currency. If somebody counts the currency using the machine and say, oh, this law doesn't apply because these dollars or pounds were counted by the machine. So this law doesn't apply because it was counted by. So where are we heading with this? Can we do this? That we have those, currency counting machines for dollars, euros, pounds, and then this case law comes that the laws pertaining to anything as far as under no circumstances is concerned, that let's say there's a law that's under no circumstances made this machine, or you're not allowed to count some currency or something and say, oh, well, I didn't count it, the machine counted, and this law doesn't apply to machines. These are vote count machines we are talking about. This is talking about the election process. This is talking about the election results. And those machines are being controlled by the registrar office, by the registrar himself. And he's saying that you cannot apply that law on us because the machines are doing the counting. And under no circumstances it should not apply to computers. Think about it. Think about it. How weird is that? How unfair is that? How unacceptable is that to a common mind? I'm fighting for it, and I will continue to fight for it. I'm going to reach out to the Court of Appeal again to make sure that the status quo in the matter remains, so that the judgment of the void judgment of the trial court is not taken advantage of or is not misused, because it's a void judgment. And I'm sure that the registrar office is going to start trying to count votes early, saying that, oh, the decision of the appeal has not come yet, so we are still going to go with the judgment of the trial court, because they said that we can do that we can count ballots before 8 p.m. election day. We can do it because under no circumstances terms do not apply to computers, and the trial court already gave their judgment, so we're going to continue to start doing that. I reach out to you, the registrar office, the board of supervisors, secretary of state, and the American people, the law and the constitution, the governor, the president of the United States of America. There's got to be the obedience of law. There's got to be the compliance of law. We cannot twist and turn, because if we do that, we are going through a wrong path and we are leading a wrong example for everybody else, especially the opposing forces that may take over the helm of affairs and use this to even further disadvantage of our future generations. So I call upon, once again, the Registrar LA County, the Board of Supervisors, Secretary of State, California, Governor, California, President Biden, most humbly, with folded hands, let's comply with the election codes. Okay? This matter is in Court of Appeal. The judgment of the trial court in Raji versus Secretary of State is void, because the judgment tried to change the election code. Not only the interpretation of the election code, but added words to it. And that has made the judgment void. The appeal has been admitted, and there's an automatic stay in the matter. I reach out to you, everyone. Please pick up your phones. Heat up your social media. Let's stop this menace of malconduct. Why is it being done? No, it's not being done on goodwill, okay? There's money playing a role somewhere. I don't know. I don't know the reason, but I know the malconduct is there. I've proven my case. So I reach out to you. The biggest way to do this is vote for me. Make me, despite all the obstacles they throw, despite all the tools they use to hold me back, vote for me. Let's come with an overwhelming majority and prove the voice of the people that we will not allow malconduct to run in our operations anywhere, whether it's elections or any part of our society, whether it's increasing prices, whether it's unaffordable housing, whatever there is that's hurting the people, I'm going to fight for that. And I've shown my proven leadership in fighting single-handedly, alone, in court. And I will do it for you, each one of you. Each one of you, you can count on me. Each one of you out there listening to me, you can count on me. If there's any injustice, you come to me, I will fight for you. I will fight for you. I will fight for your rights. Vote for me this coming election. My name is Raji, congressional candidate, District 32, California. I'm your friend and your brother. I need your vote. Thank you so much. And thank you so much for your time. Please like and subscribe, share as much as you can. I appreciate it so much. Thank you.